Hello again. I'm aware that recent court cases have alarmed some people and led them to suppose that their freedom to express unpopular views and opinions on the internet might now be restricted. The case of Alex Jones in the United States and that of Alex Belfield in Britain have both sent shockwaves, prompting some of us to think in that way. The point to bear in mind, of course, is that the law has not changed at all, and nor has what is acceptable and what kind of behaviour is apt to land you in trouble with the courts. Every new means of communication which appears over the centuries, whether it's printed books, newspapers, the telegraph, telephone, radio, cinema, films, television or the internet, seems so novel at first that some people assume that all the old rules and laws no longer apply. It is this which has caused the current spate of anxiety, with people claiming that free speech is dead, or that there is some new definition of stalking or harassment or defamation which is going to be the ruination of free speech. It's not true. Exactly the same constraints upon free speech operate now, just as they always did. Let's look at one or two examples. In Britain, if I send a message to somebody containing information which is untrue, and this causes the person who receives the message to feel anxious or distressed or upset, then I'm committing a criminal act, and the police can prosecute me. The current law which covers this sort of thing was passed before the World Wide Web even existed. It is the Malicious Communications Act of 1988. I give a link to this law in the description to this video so that people can see for themselves what it says. Of course, there were similar laws before this in Britain and the United States, but in Britain, this particular act superseded all those others. It says that, and I quote, "Any person who sends to another person a letter, electronic communication or article which conveys a message which is indecent or grossly offensive, a threat, or information which is false and known or believed to be false by the sender, which is guilty of an offence, if his purpose or one of his purposes in sending it is that it should, so far as falling within paragraph A and B above, cause distress or anxiety to the recipient or to any other person to whom he intends that it or its contents or nature should be communicated." Right, that covers emails, phone calls, texts, letters, even speaking to somebody and sending a message verbally. This has always been the case, but we somehow don't realise that doing stuff on the internet is just as unacceptable as doing it in old-fashioned ways. Does anybody remember poison pen letters? Somebody would write to a person anonymously, saying something untruthful about their family, perhaps, suggesting to a woman that her husband was having an affair, say. This was illegal, and people were sent to prison for doing it. Of course, these days, anonymous communications saying spiteful and untruthful things are so common on the internet that we don't recognise them as the old-fashioned poison pen letters, which is precisely what they are. But they are the same thing, and they are just as illegal. I always use my real name on the internet, and I only have one email address, which includes my name as simon.webb. I was always taught that if you have something to say, then you should be willing to put your name to it, which I do. However, many people send anonymous messages these days as comments or directed to individuals, saying false things designed to upset the person who reads it. Free speech in this country never included poison pen letters like that, and so prosecuting people for writing them is not new. What about the case of Alex Jones in America, though? Surely he had a perfect right to express his views about the Sandy Hook shootings. Here again, the law hasn't changed. Neither has what people can and cannot do. I was thinking of this case recently and reminding myself of similar cases going back 100 years or more. This book is a history of various defamation cases, and it's quite a comprehensive account. It was published in 1953. And God, only cost 2 shillings, which would have been a bargain at that time. It contains the case of the first libel by a cinema film plot, which was a novel idea. It's Yusupov versus Metro-Goldwyn-Mayer Pictures Limited in 1934, which concerned the assassination of Rasputin. It had never occurred to anybody before that a movie plot could be libelous, because moving pictures, particularly talkies, were so exciting and new that people at that time just assumed that the old rules of things like defamation didn't really apply to them. They did. So it was in the case of Alex Jones. The law of defamation is just the same on an internet site like Alex Jones Infowars as it would be talking to somebody in the street or writing a newspaper article. As I say, we sometimes forget that all those old rules which we have known about for years, things like not sending anonymous letters containing falsehoods and not libelling people or threatening them, apply just as much to a relatively new method of communication like the internet as they did to letters and newspapers 50 years ago. The law hasn't changed, and neither has what we can or cannot do or say before we're likely to end up in the courts. A good rule of thumb is probably to use our own name and make sure that other people know who we are, and to avoid saying anything which might be false or untruthful and likely to upset somebody else, or bring somebody into hatred, ridicule or contempt, as the old expression said for libel. If we stick to those simple rules, I think we should be okay.